Hey everybody, Craig DeLuz here. We are here with Brandon Combs. He is the executive director of the Calguns Foundation. And today we had a chance to attend the oral arguments for a very important case here in California and I believe nationwide. DOE v. BECERRA, formerly DOE v. Harris. So let's let Brandon let you know a little bit about the case and a little bit how oral arguments went. Brandon, how you doing today?
Great, thank you.
It's a pleasure to have you here.
It's always a pleasure.
So tell us about DOE v. BECERRA.
DOE v. BECERRA started out as DOE versus Harris in 2014 when the Department of Justice overnight changed its policy on whether or not somebody who had a federal government license and a state license could acquire more than one handgun in any 30-day period.
Wow. Okay, so in other words, there was a law. It had been interpreted for a period of time. The Attorney General decided, yeah, we want to change how we interpret that law, and they just did it.
Yeah, on their own. The law is very clear, and I think that anybody who reads the law would agree. The law says that no person can apply to purchase more than one handgun in any 30-day period, except unless you're a member of a class of, there's 13 different exempted classes, and one of the exemptions was if you had a certificate of eligibility from the Department of Justice, which is a background check, live scan, fingerprints, the whole works, and a curio and relics license from the federal government, an FFL. And so if you had those two things, then you're exempt from the law. That's the plain language. That's what it says, and we think that alone is sort of suggestive of what the legislature intended there. But the DOJ said one day, many years, over 10 years after their first interpretation, which was to do exactly what the statute said. And overnight, they sent out a memo, a policy advisory letter, to dealers saying, effective immediately, you can no longer do this, and if you do, it's a crime.
So now there's really then two issues here. One is the idea of an executive branch agency or an executive member of the executive branch deciding that they were going to write law by doing something that was not included, not mentioned in the original statute, correct?
That's right. I mean, there's the statute and what the statute says, and then by executive fiat, the DOJ just declared the law to be something else, and they didn't even follow the rulemaking process in the Administrative Procedure Act. So even if the statute were somehow unclear, which we don't think it is, but even if it were unclear, they didn't even follow the rules for making rules, and so that's why we had to file the case was to make sure that government is doing exactly what it should and no more.
Well, and that was point number two in the case, which, by the way, kind of transferring over to talk about the oral arguments, that really seemed to be something that the justices really seemed to grab a hold of today, and seemed to be kind of at least from what they were saying. You can never tell where they actually are, but based on what they were saying, it seemed like they were pretty close to believing that if nothing else, everything else was true. At the very least, you have a process you were supposed to follow, and you didn't follow it.
Yeah, it seemed to me that the justices were asking fairly direct questions of the state and sort of going, okay, well, why do you think this? I mean, can you give us something here? And then, by the way, even if there was some sort of an ambiguity, then why did you not promulgate rules? Is there not a process for that? And I think that the questions the justices were asking were kind of to that effect that, look, we have rules and there's guidelines and processes that we have to follow. That's the law. And I think that sort of gets to the core of the case. If the Attorney General and the agency that's in charge of enforcing California's laws doesn't follow the law itself, I mean, we have a pretty fundamental problem at that point. And so, we originally, back in 2014 when we filed the case, this was especially about the handgun issue and whether or not a law-abiding person who has, multiple background checks, et cetera, precisely, by the way, the type of people that the legislature, when they heard a prior bill, decided that these are exactly the law-abiding people that we don't need to worry about. The question is whether or not the DOJ can just one day snap their fingers and make the law what they want it to be.
Right. And what was funny was they talked about how, quote unquote, well, we can ignore the common sense, the plain interpretation of the law if the outcome is absurd. And to them, they're pointing, well, this was the intent of the law. Well, I think there were two things that we pointed out that, or at least the attorney for the Calguns Foundation pointed out that were very, very clear. One was that, there are other places where they had clearly stipulated differences in classes and laws, and if they could have done so here, right?
Absolutely, and where the legislature wants to talk about a specific type of firearm, they do so. We see that with unsafe handguns, or what are so-called unsafe handguns in the handgun roster. We see that in antique firearms. There's a definition for that. There's legislation and statutes speaking directly to those. Even so-called assault weapons, they get very granular going to make and model. Where the legislature wants to say what something in particular, they do so. And courts have to assume that that's what they did, unless there's a reason to think otherwise, like legislative history, if there's something that's unclear. And again, the core argument of the case is this is not even a close call. The plain text of the statute says what it says. Now, DOJ might not like that, but that's not their place. They're not the legislative branch. There's a separation of powers issue there. But even if it was unclear, the bottom line is that the Administrative Procedures Act requires the DOJ to promulgate that, notice the public about the fact they're going to do it. They have to invite public comment. Experts, organizations can weigh in, members of the public. Everybody can have a say at that point. There's a hearing. And through that process, you arrive at a regulatory conclusion that sort of has to check all those boxes. That wasn't followed. DOJ simply one day sent out effectively an electronic Post-it note and said, by the way, we're changing our mind after more than a decade. The former Deputy Attorney General in charge of the Bureau of Firearms, she said it was their long-standing policy that all handgun transactions with these law-abiding people that were in this class that had these two licenses were exempt. And one day they changed their mind, they sent out a notice, and effective immediately, if you take advantage of the statutory right, you're a criminal.
Well, and to even take it to one other point of absurdity, I just found it interesting that one of the justices even made it a point to say, so what about the other exemptions? For example, if I started a motion picture company, I could go buy as many handguns as I want, as quickly as I want, with no federal license at all. Isn't that, in fact, absurd?
Yeah, and I think that goes to that kind of goes to the legislative problems with these types of bills generally. When you have a gun control act and you have some sort of prohibition, but then you say, well, all of these people can do it, right? It's kind of, my opinion, it sort of undermines the entire intent. But nonetheless, we have these exemptions, we have the statutes we have, and when the justice brought up the motion picture television studio, the television, when the justice brought up the television and movie studio exemption for this and said, well, you don't even need a federal license. You could just start up a studio and get as many handguns as you want. You don't really need to be in the movie business even. You just have to have a production company. And those aren't about curio and relic handguns. Those are about modern semi-automatic firearms or revolvers. And so the state didn't really have an answer for that. And I think that's going to be difficult to deal with for the state.
Now, overall, it really just kind of seems like, let me take a step back. What's next? Let's say we get a favorable ruling. Well, first of all, what are the two possible favorable rulings that could come out of today's oral arguments?
I think that, should we have a favorable ruling in the case, there's sort of two ways I can see this going. One is the court says the plain text of the statute says what it says. These words are not ambiguous. It's very apparent that the legislature said exactly these things for these reasons. We don't get to question that judgment. They made their decision, and so the text rules the day, and that's it. That's the end of the analysis. I think that would probably be the best case. But I think the second potential favorable outcome that we could see is the court might say something like the text is fairly clear, but because there are sort of competing interpretations, clearly there are, because there's adversarial parties here to this case, DOJ and us, and our plaintiffs. And so even if there is some sort of a competing analysis on the interpretation of the statutes, that it has to follow the Administrative Procedure Act rulemaking process. And because they didn't, it's an illegal underground regulation, and strike that down.
Okay, so what impact does this have on broader rights in general, and even more specifically on gun rights in California and the nation for that matter?
Well, I think that the first thing is always about the plaintiffs in the case. These plaintiffs have a CNR and a COE. They should be able to acquire the handguns they wish in a lawful transaction in accordance with the statutes and the exemption that they fall under. So that's the first level. The second level is if you have a CNR and a COE, then this exemption would apply to you as well. And then you start going out from there. Importantly, this is one of those cases that might be more important today than when we filed it, even because with Proposition 63 and some of the ammunition statutes, if you have a CNR and COE, the general prohibition against what might be called mail order ammo or online purchases, having to go through an ammo vendor, you're exempt from that. You can have ammunition shipped to your home under the statutes if you have a CNR and a COE. And so if we get a favorable ruling, then I can see that exemption will continue to be enforceable against the government as a statutory right. However, if the Department of Justice is able to sort of make up the law as it goes, I could see a future in which they just continue to do that in other places of law. And I think that's anytime you have an opportunity and a good opportunity in a case to challenge the government and keep it in the boundaries where it's supposed to be, you have to do that. And this case could be a sort of bagging up. This case could fundamentally protect people for future ammunition purchases and mail order ammo, and I think that is really on everybody's mind right now.
Okay. I think I can also though see, and I think you kind of hinted to it a little bit, where this is a message to DOJ that you need to rethink your role in the governing process. That it's really kind of help to put them in their place in terms of saying, look, it's not your job to make law. It's your job to enforce and administer law. That's it. If there's something extra that you want, if there's something extra you believe needs to be there, well, then guess what? It's the legislature's job to do that, not yours.
Yeah, that's right. I mean, the Department of Justice has lobbyists. They employ lobbyists. If they want to change the law, they have the same opportunity that everybody else does to find members that are sympathetic, carry a bill, and through the democratic process and debate, they can try to get the law changed. And if they don't like this, they can attempt to do that. But I think when an executive branch agency just decides to make up the law and say, well, it's, if these people are right, then that means more guns. And, that's an absurd result because our policy preference is that we don't like guns or we don't like gun owners. Frankly, it starts to sound like a South Park episode. And I don't think that that's good government. And I think that's the reason why the Constitution of the state and the statutes and the APA have those checks and balances to make sure that these agencies just can't go out and make whatever law they want. The legislature's job is to create statutes, and the governor, if he approves them, those are the laws that we live under. The DOJ doesn't get to make up the law at once simply because it would choose a different law.
Exactly, and it's kind of sad that they in fact think that they can. Well, anyway, Brandon, how do folks follow both this case as well as other cases and other work of the Cal Guns Foundation?
Well, we'd love for them to go to the website, calgunsfoundation.org. We're also on Facebook and Twitter, and learn about some of the cases that we're involved in. We've got 2 at the Supreme Court right now, Sylvester versus Becerra, as well as Teixeira versus Alameda. Hopefully, the Supreme Court will weigh in on those as well. But there's always a lot of cases and things going on, and we hope people will get engaged and follow along.
Well, thank you so much. Well, everybody, that's going to be it for today. Once again, Brandon Combs with the Cal Guns Foundation, fighting for our civil rights here in the state of California. We'll talk to you later.
If you like our videos, follow, subscribe, like, and share.